Yeah, cool. Hey, right, everyone. Welcome to this evening's live stream. Shannon's not with us this week, and Will is just dealing with connection issues. Here he comes now, actually. Let me just do the old back office stuff here. I wish there was a better way of doing this, but there isn't, I don't think. It's got to manually click some buttons. Here we go.
I'm
Yeah,
back.
cool. Hey, you right, Will? Hopefully you're all sorted. So hey, right, Michael. So we've only had one question coming through the week this week. It is just about anonymized, so I guess we can start with that one. But if you want to put a question into the live stream, don't hang about because it might be another 10-minute one. Hey, you right, Katie? So I'm trying to think if there's any news from my end. Me and Will are doing the homeless application flowchart free webinar tomorrow, but it's all booked up. So but the recording will be out in a week or so. So keep an eye out for that. It should be good. Other than that, I feel like there's some news, but I can't remember what it was. Will and Karis, you any news to share or anything? You guys doing all right?
Well, I've got one bit of news. Well, it's not my news, but I just wondered how much people know about it because I got a message this morning from the Housing Ombudsman's website or something saying that AWAB's law is coming into force on the 27th of October, 2025, which led me to wonder how many people, hands up, who know who knows what AWAB's law is. Because I don't. I know it's to do with disrepair.
So
Um,
I've been waiting until they actually announce it before kind of reading
yeah.
into it too much. But I think my understanding is they're kind of staggering it. So I think they're going to first apply it to social housing, then they're going to apply it to
That's
the
right.
private sector down the line. I
Yeah.
saw Giles Peaker do something about it, but I didn't read it yet. And so I've kind of
Mm.
kept my head out of it until they actually finalize what it is
I'll
that
try and do a
everything's going
little
to be.
bit for it for Monday and for my
Yeah.
show, just talking about because the Ombudsman's produced sort of guidance on it and it looks quite user friendly.
Yeah. Okay. Um, so let me get a screen up and running so we can just start putting questions up there. So the one question we had in from the week is this one here. I need to share my screen, but hold on, let's get it up there first. No, not that one. Bear with me, guys. I'm being inept again. Let's try that one. There we go. Cool. So question one. Let me just collapse that down as well. Yeah, question one. Southend Council have told my friend that if she's accepted for main duty, that she then won't be able to bid anymore. Is this true? Now, I have had dealings with Southend before. I was not impressed at all, I've got to say, but I don't know their policy well enough to actually know the answer specifically. But I can probably give the answer without knowing the specifics because if you are owed the main housing duty, then you have to be given what's called reasonable preference on the housing register, which means you have to be given a banding, even if it could be a fairly low one. And you would then, once that's kind of processed, which shouldn't take too long, you would then, you would be able to bid. The only way they could, I mean, they can't say you definitely won't be able to bid. One thing they might be able to say is that maybe they do direct offers there or something. Maybe they don't give people choice. I'm not quite sure. So that's an option. They might say, yes, you're on the housing register, but we're going to give you a direct offer. You're not going to get any choice in it. I'm not sure how many councils do that, and I'm not sure if that's actually legal. Or it might be that they're going to discharge the main duty into the private rented sector and they know that already. But again, I'd be surprised if they know it already. It depends what kind of the timings are here. So my guess is it's probably not true. And what I'd certainly say from my dealings with Southend is that I wouldn't trust what they're saying. I don't trust that they know what they're talking about at all. So the fact they've said it probably doesn't is not kind of what you want to be as using as an authority. What you want to do is go to their housing allocation scheme, which is kind of like their official policy, and read what the small print says about people owed the main duty. If we get time tonight, I might have a little circle around in the Southend policy tonight, just to see if we can find out what the answer is. So yeah, I'll kind of come back to Southend if I can kind of get to it quick enough. But that, as I say, without kind of knowing the exact details, that's probably all I can say at this point. I don't know if Will and Karis can shed more light than I can about that. No.
All
Okay,
I would
cool.
say is it
Oh,
is something people do say quite a lot. It's a bit like we can only, we can take your children into care if you want. It's the sort of housing department, one of the housing department's equivalents is to say, well, if you want to go down the homeless route, you can, but you won't be able to bid for anything. Is that what you want? And you'll only be able to get private sector or bed and breakfast. Um, so it maybe it's one of those things, but I'll have a look at allocations policy as well. I've just Googled it up, so
yeah,
I'll
have
just
a little
sort
dig
of.
around because I might open it up and share the screen in a bit and we can have a little look together. Um, in fact, I think Karis just showed the link to me. Thanks, Karis. So in the meantime, let's just get into the live stream straight away, and then we will come back to Southend's policy in a bit more detail. So question 2 is a multi-parter. Just to say, guys, do use the opportunity to put a question during the week because you don't have a character limit, which means you don't have to spread questions over multiple things. From my point of view, it just makes it quite difficult to follow, and I will sometimes miss things because of it. So as I say, if you can, have I just copied the same thing twice? Don't think so. Let's read it and see if it makes sense. So family submitted a complaint to the LGO following a homeless application. Several complaints and review requests were made to the council, but they received no response. After initial assessment, LGO temporarily closed the case and forwarded a copy of the complaint to the council, asking them to respond within a given time frame. The LGO stated that the case will be reopened if the family is not satisfied with the council's decision. Have you ever encountered a similar case? Probably to answer that question, I need to know, did this family did they go through the council's complaints process first? The similar situations I've been involved in, I remember with one council, I did the first stage complaint, had to wait ages to get the response. So I just sent the second stage complaint without actually getting the response, I think. And then again, they didn't respond, but I kind of waited for their policy time limit. And then once they'd exhausted it, I kind of went back to them one more time and said, I'm going to go to the LGO if you don't respond to me. And they didn't. So I then sent it to the LGO. What the LGO then did was they contacted the council saying, are you actually going to respond to the complaint? Which they eventually did, but it still had to go back to the LGO anyway because the council's response was terrible. So that's one situation. There is I can't. I've been going through these LGO decisions to kind of keep this database kind of nice and plump. And there is a case in there somewhere which I remember reading where I think it was in the case of urgent domestic abuse where the survivor complained to the LGO and she hadn't gone through the council's complaints process at all, but the LGO decided to exercise its discretion to investigate because of the urgency of the situation because she was still homeless. So I don't know where I'm going to find it at some point, but I don't know where I'm getting that from. I don't know which case it was. So again, if there's some ridiculous urgency going on here, then maybe the LGO would step in sooner. So there's like a 45-second lag on the stream here, so it might be that the person's going to take a little bit of time to answer that question. So yeah, my question is going to be, did this family go to the councils or through the council's complaints process already before they went to the LGO? And that might kind of help us home in on the answer. So meanwhile, whilst we're waiting for that, um, let's go to this question here. Bear with me. Is that going to copy and paste or not? Nope. Awesome. Hold on. Let's try that again. Right. This is part 1, I think. Okay, 3 parts, I think, just 3 parts. So here we go. A person is waiting for a Section 204 housing appeal at County Court, unsuitable accommodation because of physical health problems. Can the solicitor refuse to apply for interim accommodation with County Court? How long is the average wait for a hearing at County Court? Is it between 6 and 12 weeks for the actual hearing? Also, can the council ignore formal complaint and not reply at all as person submitted a formal complaint almost 2 weeks ago and still no reply or acknowledgement? Thank you. So let me answer the second bit then, and I'll hand it over to Will or Karis to answer the first bit because I don't know what the answer is. But in terms of, I mean, what you need to do is, again, I can't give you the exact answer. You need to look at the council's complaints process because in their complaints policy, they'll set out time frames. So, I mean, 2 weeks is not unusual for the first stage to be responded to within 2 weeks. It's not unusual to not get an acknowledgement from the council. And this is one of the reasons why I copy councillors in because you kind of get a bit more activity and a bit more response. So yeah, so the council, I mean, yeah, kind of similar to what I said before. If a council has had fair chance to respond to the complaint and hasn't, then I would take it to stage 2, and it's basically going to be exactly the same question again. It might be useful for you to go on the LGO database that's on Will's website that I've talked about. It'll be in the description of the video at the end of it, because there's a lot of cases involving unsuitable temporary accommodation based on physical health problems. So you will kind of see how the LGO takes complaints forward, what kind of things they look at, that sort of thing. And my guess is that the LGO's response will probably be, if you get that far, is going to be to say that whilst the county court process is kind of happening, they're not going to be able to give a decision. They might be able to make a finding about whether or not the council carried out the right assessment about the suitability, but they won't be able to actually kind of give a decision about the suitability itself. So that's my answer to the second part. Will or Caris, can you answer those 2 other questions? So can a solicitor refuse to apply for accommodation? And what's the typical time span? That might be a bit of like how long's a piece of string, because it would just depend on which court it is and stuff. But I mean, yeah, what would you do if a council, if a solicitor refused to push for accommodation whilst the appeal takes place?
Do you want to have a shot at that, Karis, or should I dive in?
But you go for it. I think we both unmuted.
Okay. Yes, I mean the answer to the question, can a solicitor refuse? I mean, yes. They can just say no, I'm not doing it. The question would they be justified? Could that be said to be justified? And the answer would be yeah, it could happen. For instance, see what we're talking about here is where you've applied for a Section 204, where you've issued a Section 204 appeal in the county court. And the problem with that is it can take longer than 6 to 12 weeks. It could take 3 or 4, it could take 4 or 5 months to get a final hearing. So the question is, what about while that's going on? For instance, if they said you're not in priority need, so we're not going to house you, in theory, you're going to be homeless during that time, which turns out to be very unfair if you win the appeal. But in order to challenge a refusal to give you accommodation while you're waiting for the appeal, you'd have to issue a second appeal, which is called a Section 204A appeal, and you'd have to show that the council have made an error of law in refusing to provide you with temporary accommodation, which is very, very difficult. It's not just saying it's unfair, but it's so a solicitor would have to justify the expense to the legal aid agency of taking that step. And if they really didn't think there was grounds for doing so, they would have a duty to the legal aid agency, not just to go running off spending money which couldn't be justified. So if the solicitor said, I think you've got a poor prospect of success, I mean, it wouldn't be them refusing, it would be them saying, I'm sorry, my hands are tied. The legal aid agency will only give me clearance to go ahead with your second appeal if I can say that you've got a good prospect of success. And I can't. So but you may say, well, that's the same thing, really. If you could talk my prospects of success up, I'd get legal aid. But sometimes they may have to draw a line. So it's very unfortunate. But I'm not, without knowing more about the facts, I can't really say whether or not it's fair in this situation.
I think potentially what the LGSCO decisions that they would give you some good understanding of kind of what suitability actually means in the real world. So it might give you a kind of an understanding of whether or not there would be merit in the challenge. Again, it's not the LGO is not the law as such, but they do know the law very well. So I just wonder if that might be a helpful thing just to kind of have a look in the decision database. In fact, I might be able to get the link for it now. I'll put it in the chat, because what you can do with this is, in fact, I'll show you. So there's the link, and if I just kind of unshare this for a moment and go back into that, I'll just give you the examples because unsuitable TA is such a common issue. So if we just go to whether the search has gone over here and go unsuitable TA, and then we get like all these cases here. So I mean, I don't know, pick one for Tower Hamlets. Take the number here, and then we go to the LGO decision website, stick that into the reference number here and search, and then we get the actual full decision. And so again, where's the actual thing here? So this is actually probably not the best example because what's happening, this is like a major report. So this is like a part of it. But it kind of you'll see by reading these kind of what's relevant to suitability and how councils are supposed to consider it. So, and they're quite, I mean, the LGO quite often gives quite relatively large payments for it. So I can't see what amount. This is like an old format one. Let me see if I can get a different one actually, just to kind of maybe show a better example. Get to it. So hold on a minute. Let's go unsuitable TA again. Yeah, let's go to this one of Bromley. Again, just stick it in there. Bear with me, guys. Sorry about it's taking so long, but so again, you kind of, I mean, here, like we're talking £2,500 compensation, which in LGO terms is quite big. But again, you've kind of got, again, a detailed explanation of what the law is. And I mean, this is talking about discretionary housing payment for some reason. Yeah, there'll be stuff about suitability TA in here, which is why they got, yeah. So there's clearly stuff about unsuitable TA. Have a look at that, and just kind of, I think that's a good way to learn what the law is without kind of having to dive into kind of all the sort of section numbers and stuff of the Housing Act itself. So yeah, I think that might be the best we can offer, unfortunately, in terms of an answer here. There has been a clarification for that question too. So yes, the family went through the council complaint internal process, but no response. So okay, so yeah, I mean, this family's done a good job, by the way. And the council's just using weaponized incompetence to try and duck it. So just, I guess, rule number one is keep going. But what I think the LGO, what their primary purpose is to try and get the council to resolve things without the LGO having to investigate. So I think I think it's nothing to worry about at all. The LGO is basically probably just given the council 2 or 4 weeks to actually respond properly. And then if you're not happy with the response, then you just simply go back to the LGO and they kind of, they already you already got in contact with them. I saw an interesting one today, which I've done a little video about involving Milton Keynes, where the second stage complaint was upheld and Milton Keynes offered £100 and the family were like, go off you go, sort of thing. They went to the LGO and the LGO like offered like £1,600 or something. So I think it's probably quite likely that the council's second stage response or final response won't actually be very sensible, and you'll probably have to still go back to the LGO later. But I don't think this is anything to worry about for the time being. I think that's just kind of how it would work. That's pretty normal. You like Cheeseface? I think I saw Tiff in there somewhere as well.
Yeah.
You right, Tiff? You right, Anton? So yeah, I'm not sure if that was a particularly happy answer, but I think that's what the answer is to number 3 there. I think what Will said. There's a question here. I mean, we'll talk about it because it's a good question. It's not exactly housing law exactly, but question about the benefits cuts and stuff. I mean, I'm not quite sure what's getting cut. I don't think the PIP is going to get cut in the way that it is planned to be right now. It seems to be that Labour backbenchers are basically rebelling quite effectively. So there's kind of, I think it's being paused. But in terms of this kind of question, there's a guy called Joe Halewood, and I mean, he's got a blog somewhere. Yeah, I'll put the link into the chat. This guy, I don't know him. I think I've spoken to him on the phone once or something, or had a message with him or something. But I kind of follow him on LinkedIn because he clearly knows what he's doing when it comes to benefit stuff, and he is at every opportunity basically talking about it. The biggest problem that benefits got right now is the benefit cap, because the benefit cap basically means that any family, sort of 3 or 4 kids, is going to be unable to afford their rent. And that means there's no motivation to build 3 or 4 bed homes from social housing providers, because who the hell's going to go and live in them, because people can't get the rent for it. So but the reason I mentioned Joe Halewood as well is he's put some stuff out recently about some changes. To be honest, it's all gobbledygook to me because it's all kind of really kind of in-depth housing benefit and benefit stuff in general. But his view is that that there's these kind of like this perfect storm of kind of benefit sanctions and changes and stuff that's happening, which is going to most likely make homeless levels kind of skyrocket in a year or two. So yeah, I've got nothing else to say. I mean, it's a great question, as I say, maybe one for one of the informal live streams we do. But it's yeah, I don't know if anything's set in stone as to what's happening with benefits. I might have just missed something. If Shannon was here tonight, she kind of does a lot of work with DWP, so she'll be able to kind of tell us probably more. Cool. So again, there's a question about housing benefits there, which I don't think we're going to be really qualified to answer. And a question about staying on legacy benefits, I think the answer is no, but I don't know. I don't think it's just not our area of work really. I think that's it. I think that's all the questions, guys, this week. So it's a bit of a short one. That's just happened sometimes. So unless I'll give you like 30 seconds or 45 seconds just to put any final questions in there. If not, we'll have an early night basically. Well, it appears to have frozen. Oh, yeah, go on, Will.
While we're waiting there, can I just go back to that one about the solicitor refusing question? And this isn't about the actual solicitor's refusal, but one tip I would give for people in the review process and the homelessness appeal process is that you can make use of the time delays to obtain further medical evidence. And this is particularly true with mental health problems because it's very, very common indeed for single men with mental health problems to have their mental health conditions completely ignored, either in terms of finding them in priority need or in terms of giving them suitable accommodation. So part of that problem is caused by the fact that a lot of people just treat mental health problems as something you live with rather than something you get cured for. And also GPs, I'm sorry if I go on about this a lot, but GPs aren't particularly good at dealing with mental health issues. And so there isn't much evidence. And so the council can say, well, we don't think there's much evidence. And just an example I could give is I've been dealing with quite a lot of people who are refugees and have been traumatized by experiences in Northeast Africa a lot of the time, sort of Somalia, Eritrea, those sort of places. So they've had a horrible time leading them to flee the country and then terrible time crossing across Europe to get to here. And they're suffering from post-traumatic stress disorder, which again gets ignored. And I had a case this week where a council had refused to accept somebody who was vulnerable. I managed to, during the review, I managed to get a report from a psychiatrist who said, yeah, this guy's got serious post-traumatic stress disorder. If he's street homeless, X, Y, and Z will follow. I think I sent the report within 24 hours of sending that report. The reviewing officer had pulled the decision and accepted and he'd gone further and said we accept a full duty to house him, which he didn't have to do. So it is worth doing that. And a lot of solicitors will be wary about this because they might say, oh, Will's talking rubbish, because a Section 204 appeal is just about an error of law in reaching a decision on review. So that by the time you go to court, you can't really get new evidence because it's history. But you can, I think, because you can justify the expense to the legal aid agency of getting what can often be an expensive psychiatrist report, because you can say that this demonstrates what the council would have found out if they'd carried out a proper housing assessment, made proper inquiries. And so it's relevant to show the error of law in failing to make adequate inquiries. And if that fails, you can always rely on it as new evidence if you lose the appeal. Some people may say, well, that's a bit of an abuse of the process, but I don't think it is. I think it goes to the heart of it, really. So you might want to ask your solicitor to think about, I'm not saying this particular solicitor, but in general, say, is there a chance you could make a referral you could instruct a specialist? And I've been doing this for a long time. The legal aid agency have never criticised me for famous last words, but have never criticised me for doing this. And it is like £1,800 a throw, but it's usually money well spent because the council won't argue it, and now medical can't really put a negative spin on a psychiatrist report. So sorry, that's a bit of a speech, but just a bit of a reassurance. You can try and get some more medical evidence because this one's relevant because it's physical. Well, it's physical health problems, so a psychiatrist wouldn't help. You but you might be able to dig around and get more medical evidence. That's what I'm saying.
Yeah, I think Now Medical could have a go at, they could try and dismiss a psychiatrist report. It just wouldn't be successful if it ever went to court. I think well, certainly councils are quite apt to prefer Now Medical over pretty much everyone. But anyway, that's another issue. Thanks, Will. I am just trying to dig out a bit of a quote that's going to help us with the next one. Where's it gone? So, have I just, bear with me a sec, guys. Need more screens. Nope, not that one. That's the blog. So I think this is the next question here. So yeah, can an individual currently living in interim accommodation on their own accord apply and move into a YMCA or domestic abuse refuge? Will this result in trouble for the individual by the council? So really good question. This needs a little bit of unpacking, and that's why I'm just trying to desperately find a slide from the training I deliver, because it's got a little bit. There's a case called Edwards v Birmingham, which is a really important case around interim accommodation, among other things. And so if I just share this screen, I'm going to zoom in a bit actually because it's in the small print, so bear with me a sec. Here we go. So first of all, this is just kind of, this isn't the section we do on the training about interim accommodation. So first of all, it's saying that the interim accommodation duty is low and indeed clearly low by design in view of the vulnerable individuals it's intended to protect. But then this case, oh, hold on a minute, I can't zoom in, can I? Or can I? No, I can't. Hold on, let's try something else. Is that going to do it? Nope. Okay. I don't know if you guys can read that print at the bottom there, but this is kind of in the discussion where exactly this happened. So basically, Miss Edwards made a homeless application. The interim accommodation duty was owed, but she preferred to move into, I think it was her mum's house or something, rather than move into council interim accommodation. And that would be fine as long as it's agreed between the council knows what the person's doing. But then in that case, it made the point that so long as the applicant is aware that he's entitled to interim accommodation until a decision is made on the homeless application, and so can make an informed initial decision, and knows that he can return to the council at any time to request interim accommodation, there is nothing objectionable about this. So it's potentially an everyone win situation, because let's say you make a homeless application, the council owe you the interim accommodation duty, but you say to them, look, I can stay at my friends in the short term. Any sensible council will say, yeah, that's fine. But if the relationship with a friend breaks down or whatever, then come back to us. The interim accommodation duty will kick back in. That's different from just outright rejecting the offer of accommodation. So what you're saying is, I'm not rejecting it. I'm just saying I've got a different offer. And any council that's got any sort of brain power at all will basically, grab your hand off, really. So that's kind of forms the basis to the answer to my to the question. Let's get the actual question back up again, because we've actually got two different things here happening. So the domestic abuse refuge and the YMCA are crucially different when it comes to their legal standing, because if you went into a refuge, you're still legally homeless. So that should be absolutely fine. If you approach the council, they've offered you interim accommodation, but you say to them, look, I can get a place in a refuge over here. Can I do that? But can you continue the homeless application as you normally would do? They should be like, yeah, that's fine. There's a potential risk with that, because if you do that, the council won't be paying for your temporary accommodation, your interim accommodation. And so effectively, they're less motivated to finish the review in a timely manner. I mean, generally speaking, if council's paying for you to be there, you're going to be number one priority for them to actually respond and issue a final decision, because it's going to speed you up to kind of save the money. So that's the answer for a domestic abuse refuge. However, a typical YMCA is supported accommodation. It's a different legal beast from a refuge. You're not homeless when you live in a YMCA. And so if you were to move into a YMCA, the council would basically issue a not homeless decision. They say, you approached us, you were homeless. Now you've secured accommodation in the YMCA, therefore you're not homeless, end of. And if you were then to lose the accommodation in the YMCA down the line, then you can make a fresh application, but you might be found intentionally homeless. This is probably the biggest, well, it's one of the biggest reasons why I strongly dislike supported accommodation, because it has this effect on the homeless application process. It basically cuts your options right down. And whereas if you were to make a homeless application, main duty accepted, and then you get evicted from your final home, you can still go to the YMCA. If you get evicted from the YMCA, you're probably going to get found intentionally homeless if you were to go back there. And then there's one other thing I'd probably want to just say as well about this is that you can't be found intentionally homeless from leaving interim accommodation because it's not settled. Basically, to become intentionally homeless, you have to become homeless from settled accommodation. So the same would apply to if the council put you in interim accommodation in a hotel and then you punched the manager in the face and got evicted from it. You're not intentionally homeless. The interim accommodation duty's ended because you've been a knob, but the actual final duty might well kick back in. So I'm not sure if I've done that justice. That is a good question. It's a rather complicated bit of law, but in one sense, I think that the easy answer is don't do anything unless you've agreed in writing with the council what you're going to do and you understand the implications of doing so. And if you kind of got them to write down what's the implications of accepting YMCA, what's the implications of accepting a refuge, then you make a decision based on what's in writing, because that saves you, kind of keeps you safe down the line if you want to reapproach. The final thing I'd actually say about this is that there are some dodgy unregistered social kind of like support accommodation providers who call themselves a refuge, but they're not a refuge, they're a hostel, they're a support accommodation provider, and therefore though they're called a refuge, you're not homeless there. So again, get the council to explain exactly what it is you're asking to the council in writing, and get them to give a detailed response and make your decision based on what they've put in writing. Don't have phone conversations with council officers about this. They will tell you all sorts of nonsense and they'll kind of come back to bite you. So yeah, that's my answer to that. Will and Karis, you got anything to add to that or change about it or anything like that?
Could I just ask one question? If Mo, who asked the question, is still there, I was just wondering why. I mean, not that the person isn't entitled to, but why would they want to give up their interim accommodation to move into the YMCA or a refuge? Because I wouldn't have thought. I would have thought the answer to that might be because they're not happy in their interim accommodation. And my advice to somebody would be, it's better to try and challenge the suitability of your interim accommodation rather than put yourself in what could be sort of the fire rather than the frying pan.
Yeah, I've worked with a lot of people who, in the heat of the moment, sorry
Yeah.
to build on your pun there, Will,
No, no, by all
but
means, go
yeah,
ahead.
in that situation, they make a decision to go for the supported accommodation because it's a bird in hand is worth two in the bush. I get why people do it. It's a really unfortunate that the council's put people in that situation where they're making a decision based on inadequate information. But they kind of they take the bird in hand, they go to support accommodation, and then they find that first of all the support accommodation is just as bad as the interim accommodation, and they also find that there's no move on policy, so they're basically stuck there for years. So these are all things I'm sure there's some good support accommodation out there. It's just not very common in my experience. So you kind of just want to really be careful about how it is you make this decision.
And I'd also just point out the YMCA and refuges, you'll be what's termed a license, so you may have less protection in terms of your tenancy agreement from interim accommodation. You're there under a statutory duty, whereas in supported accommodation or a refuge or YMCA, you might not be termed under the same conditions, and you'll have less protection from eviction with limited notice.
Yeah. Yeah, and I've seen people being evicted from support accommodation for very petty things, basically. So yeah, hopefully that's helpful. But yeah, good question. Slightly complicated answer, I guess. Next question, question 6. If the council have helped a person find private rented accommodation after 6 months, would it be worth that person asking to be put on the housing register? Would they get accepted or left now? How? So it depends on the local housing allocation scheme. I think most councils would say, no, you're adequately housed. There's no reason to put you on the housing register. But my guess is that some of the areas in the country which are kind of have less stress on their housing supply would potentially there would be policies out there which would allow you to basically join the housing register. So I think if you're in London, forget it. I think if you're probably in the south in general, southeast at least, forget it. Or Birmingham or one of the big cities or something. But if you're in the sticks, I mean, yeah, the only way to find out for sure is to look at the housing allocation scheme. You find it by just googling the housing allocation scheme plus your council's name. Speaking of which, we're going to we were going to circle back to Southend's policy before we finish, so let's try and do that.
Did you manage to have a look at it? Because I would suggest starting at page 45 if you've got it. If you've got the
I haven't got it yet, but I'll get it. Yeah, bear with me. Okay, yeah, let's just get it up and running. So yeah, Karis just all she did was just search for housing allocation scheme Southend. This is what we get. And sorry, what page 45 did you say?
Yes, if it's the same one I've got. It's got a sort of blue bar at the bottom. Yeah, that's
yeah. 45.
That's got a section on homelessness,
Yeah.
which does appear to be to support the proposition that you're worse off if you go down the homelessness route. It's looking good that you're in band B if they accept a prevention duty and you're cooperating with a personalised housing plan. But then if they put you in temporary, you're into band C, and obviously if they owe you a relief duty, puts you in band B, but the relief duty only lasts 8 weeks. So the danger is, and if you get interim, it looks like.
What a
Forgive me.
bizarre policy.
Yeah, I mean
Oh, so
I would
so
just point, sorry, just to interrupt, I'd point out there on top of page 46, 3.2, that the person that once they accept a main housing duty, you'll be placed on a one suitable offer band, and you'll no longer be able to bid.
okay, yeah. So yeah, so
oh yeah, it gets worse, doesn't it?
Mm.
okay, so what the person's been told is actually correct in the sense that it's not that you won't get social housing, it's just you won't have any choice. They'll basically, yeah, they'll just go for it basically. So there's not a lot you can do about it because it's in their policy. It's pretty. I mean, it's not the only policy like that, but it's not the norm. I mean, most councils, even when you kind of got the main duty accepted, you still get some degree of choice, whereas here you don't. But this is an example. There's 300 different policies in the country. This is just one of them, and the only way you can find out about your local area is to basically search for it. So yeah, as Kara says, they're like that's the way it's going to work here. And then it kind of says here, so if you refuse a suitable offer of accommodation, you will discharge your homeless duty and you'll be placed into band D. And I'm guessing that in band D, you ain't getting anywhere ever, really. So I guess to kind of give a fuller kind of answer, the key thing then is going to be making sure that the council knows about everything that's going to be relevant to the suitability of the offer. Because they're probably it's probably going to happen that they're going to offer you something which may not be suitable, but you need to make sure that they have all the relevant information. So I'm always in two minds about whether people should say what their preference is, because in my experience working in a housing team, if someone said they wanted a property on this side of town, they specifically get something on the other side of town just to make it less appealing, so that hopefully they give up or whatever. So I'm not sure how effective it is to ask for what you want, but you can say that you need certain things. So things like if you've got support network, if you've got mobility issues, if you've got kids in school, those are things, those are some of many things which are going to be relevant to the suitability. So you want to make sure the council has the right information there. But yeah, unfortunately, that seems to be Southend's policy. So you can't really challenge it. And I guess, as we always say, if you get offered a property you don't like, you need to accept it really, and then challenge it later. Don't refuse it because you're just playing chicken with the council then. Yeah, cool. So Michael's just asking there, so can you please explain where a person can add a question that would be added to an answer in the live stream? So literally, if you go to any video on this channel and you put a question in the comments on any video on this channel, I get a notification and I go through the notifications on a Thursday and I basically just get them ready for the live stream. So there's no if there is a character limit, it's like thousands of characters. So you can basically ask questions there. Keep it anonymous, keep it in the third person. But that just means that first of all, we'll generally answer the questions first, and also means you don't have to try and mess around with kind of multiple messages to get the question across. Yeah, question here about kind of contractors and gas safety checks and stuff. I think when it comes to get your gas capped, you've got to take it up with a gas supplier rather than the council necessarily. I mean, obviously, they're not allowed to lie on documents, but yeah, plenty of professionals do. So yeah, your only kind of defense about that is to have kind of black and white proof that they're lying. So but I don't think you don't need a court order to cap gas, as far as I know. It's gas companies do it quite regularly if people aren't paying and stuff. So I don't know. It depends what's going on there. Have I missed any? Just check it's.
Tiff's asked a question about that discretionary housing payment thing I said, which if you've got a minute, I'll just try and answer that.
Yeah, I was trying to find it so I can put it on the
Yeah,
screen.
when you, it's getting a bit higher up now, I think. Oh, where did it
I think
go?
I've got it. Here we are.
Oh yeah.
I think that's here we go. Here's the end of it. So yeah, that's the question there. So Will, I remember you suggesting discretionary housing payment application put in for rent arrears, and said you've seen cases where they've agreed thousands before. Tenant put one in and was refused. So yeah, I mean the point is they're discretionary. That's the issue.
Yeah.
So I mean you can. I mean the only reason the council's going to do it is because it's in their interest. They won't do it to be nice. They're not doing it to be nice. They're doing it because in some cases, spending thousands of pounds to wipe someone's rent arrears will mean that you're not stuck in temporary accommodation for the rest of your life, and so it saves them money. That's why they're doing it. So you can't challenge it as such. I mean, you can have a look and see if the council's got a policy and see what they've done is in line with the policy, but it's not guaranteed. It's not like a duty, as in like you can force the council to provide suitable accommodation or accept an application. You can't force them to give a discretionary housing payment.
But there's one little tip. I agree with everything you just said, Mike, but there's one little tip that maybe I didn't make clear before. And before I say that, I'll say it is very likely that if a member of the public applies for a discretionary housing payment, especially to cover rent arrears, you're going to get a sort of computer says no response. But the tip is don't make the application direct to the discretionary housing payment people yourself. Make an application to the housing department for assistance in avoiding the loss of your home. And if they accept a prevention duty or agree to look into it, then you could ask them to ask their colleagues for a discretionary housing payment as part of the plan for assisting you. And that sounds a lot better than if you make the application yourself, the reason you get a hostile response is they say, well, it's not our job to pay off your rent arrears, but it is somebody else's job in housing to help you avoid losing your home. And the other thing is you can say, I'm worried I might be found intentionally homeless. I think that one way of stopping me becoming intentionally homeless is for the council to help me with a discretionary housing payment. And then if they refuse to make the discretionary housing payment and you do lose your home and you're found to be intentionally homeless, I think you'd have a good argument to say that they could perfectly well have made this payment and they didn't. So it's not down to a deliberate act or omission on the part of the applicant that led to them losing their home. And I think that might be an incentive for people in the housing department to pick up the phone and ask their colleague about the discretionary housing payment. I hope that makes sense.
Yeah, that made sense to me. I think it kind of goes back to what you talked before about the power of the relief duty and the power of the PHP.
Yeah. My naive faith in these things.
I'm still in my skepticism over here, but yeah, no, I think I get what you're saying. I think it's a good argument to have, a little bit like the making sure that Section 190 accommodation is suitable. Like, I probably wouldn't have held much hope out for that, but you managed to show that was possible. So, so I think the next question is this one here, two-parter. If a new let's get all of it actually. If a new council won't accept an application because they say person is intentionally homeless due to turning down a property from another council, can this be argued against? It's difficult for solicitors to obtain psychiatric reports, or is it a long way? Or is it difficult for solicitors to obtain psychiatric reports, or is it a long wait? if now medical agreed to person's conditions, but then gets a second unfavourable report. So now, I mean, maybe I'm wrong. Now medical are unlikely to get a less favourable. You're unlikely to get a less favourable report than you are from now medical. Any other psychiatry, literally, I mean, this is their business model, right? Um, so I think, yeah, I would be shocked if getting any other medical evidence would be worse than what you get from now medical. Now medical, I mean, just to say, now medical would never even look at, often never look at the applicant's actual medical records, let alone speak to them, or God forbid, actually see them face to face. So it's not, it's just a bit of a bit of a, a bit of a ruse, really. So yeah, let me just tackle the question again. So, okay, first issue, you found in tenancy homes from one council because you refuse a property. You are then at liberty to approach any other council. Absolutely. The problem you've got is that whilst they might have the interim accommodation duty to you, they will refer you back fairly soon in the process. It won't be immediately if they're following the law, but it will be fairly soon. And effectively, your assistance will come to an end. In effect, I've never actually seen it happen. I saw this case recently, actually, but it was in a situation where we're able to get the second council to accept that actually the first council's decision was wrong, and that can be done. I mean, again, this is confused by the Homelessness Reduction Act, so I've not seen any case law since then. But I remember an old case, I think, involving Windsor or Slough or somewhere like that, or Swindon or something, where essentially an individual was found in tenancy homes from, let's say, Slough. They went to a different council, which I think was Ealing, if I remember correct. Ealing looked at the situation and said, no, we don't think you're intentionally homeless. We'll refer you back to Slough. And then Slough were compelled to accept the main housing duty for them. Now, as I say, it's a bit more complicated now because of the way local connection referrals work. But it's definitely, I mean, the short answer to this question is no, the second council is compelled to accept an application and provide interim accommodation if there is, if there's, kind of reasons to believe that person might be homeless, might be eligible, might be in priority need, which I'm assuming they are because the previous council probably found them in priority needs. Now, there's an additional bit to this. Now, generally speaking, I like to stay within the lines of the law, and this isn't unlawful as such, but there are certainly cases where you approach one council and they literally can't be bothered to fight another council, so they just accept it. They just basically accept the fresh application. They don't try and refer them, or if they do try and refer them, the other council will often be difficult. In fact, there's a video on the channel called "Councils Gatekeeping Other Councils," and it was based on a case, an LGO case. I can't remember. It was two councils, Runnymede and somewhere else or something. And basically, this is exactly what happened, where basically there was no local connection. There was another local connection to the other area. They tried to refer them, and the other council just basically, again, used that weaponized incompetence. And eventually, Runnymede just basically gave up and housed them. My screen's frozen. I'm hoping you guys can still hear me and see me. But okay, yeah, I'm assuming it's all right. So yeah, that's the answer to the first bit. It's illegal, but you probably need to ultimately you probably need a solicitor to kind of fight that argument. And then in terms of is it difficult to get psychiatric reports, Will and Karis will let you guys answer that. By my guess is it isn't that difficult if you can get legal aid and there's kind of merit in doing so.
Yeah, that's right. I mean, it can take a while because most of the psychiatrists that do this are doing it on not on the side. That makes it sound dodgy, but in their spare time, um, when they have full-time jobs in a hospital or something. So they might be able to do an appointment at 5 p.m. on a Friday afternoon. And I mean, it takes 2 hours. I mean, it takes a long time. But I was frustrated at first with there's an organization called Expert in Mind who I would recommend to solicitors out there, or anyone. Um, and they were taking about 3 months to give me an appointment, but they gave me an appointment for somebody today who I referred yesterday, and that appointment was for the sort of first week of July. So I was pretty impressed with that. And then it takes about another month for them to prepare the report after that. Um, and it's difficult to say this is urgent because um, in the medical profession, urgency has a sort of different meaning from lawyers' meaning of it. Um, So yeah, it's not difficult to get it. You just got to wait quite a long time. Um,
Cool.
can I just ask a question? I'm sorry, I made my mind's gone blank on that last one. But you know, if you get found intentionally homeless and you go to another authority and you haven't got a local connection with that authority, and they refer you back to the authority that found you intentionally homeless, and they refuse to accept the referral,
If
does that
it,
mean that the second authority, where you have no local connection, have to assist you?
uh,
Because, or what, where does that leave
Yeah, I mean,
your,
so my understanding is that there's two different things that could happen. One is that the other authority accept the referral, but they say we've already ended the duty to you, that we're not going to give you any more assistance. So both councils would basically end the duty,
yeah, yeah, that's the worst
or
thing.
if the or if the other council simply doesn't accept the referral, then you can have the situation where the referring council, the second council, basically just give up, and they just basically
They
proceed
just,
as if the person who made an application to them as it is. So, I mean, it seems to me. I mean,
yeah,
I've heard of it happening more often than you might realise, where literally, you see how hard councils fight to kind of not house people, but as soon as they're faced with having to challenge another council, they just kind of know what they're up against. They just give up.
yeah,
So as happened in that Runnymede case, I say it's worth looking at the video because it's got the link to the councils gatekeeping other councils. If you search for that, you get the LGSCO cases at the top of that description. You can have a look at it yourself. Fascinating, really. As I say, but yeah, so don't councils don't just play hardball with homeless people; they play it with other councils as well.
they do.
Um,
Or even between departments.
yeah, yeah.
That's another story.
Yeah. Um, well, I'm just checking I've not missed anything. So how? Okay. Uh, question 9. How long does the process take to apply for the housing register of a council, and how long does it take for them to process your application and allocate banning taking into account submitted medical evidence? So another good question here. So I'm assuming because this is a follow-on from question. Oh, I don't know where it's gone now. The one about interim accommodation, basically. So I'm assuming this person's made a homeless application. And the answer is it should really be done within a matter of days or weeks because even when you're still only owed the relief duty, you still get reasonable preference. That means you have to be on the housing register, able to bid. So really, they should be basically, yeah, they should homeless applicants need to be supplying the requested documents as soon as they possibly can, and then the council need to basically take those documents, process the application, and there's no point allowing someone to have reasonable preference if they never actually get to bid. So I think that would definitely be maladministration if a council was to fail to do that. So yeah, it should be done within. I mean, I can only talk. My only experience with that is Bedford Borough. When they're kind of working effectively, they'll do that within. I mean, I'm pretty sure housing officers actually do it whilst the initial assessment's taking place. They're literally inputting the data onto the housing register system, getting the relevant documents, and then you're basically able to bid, albeit at a lower banding because you're only owed the relief duty rather than the main housing duty. So yeah, but having said that, I'm sure there are councils that will never do it unless you complain about it and make a fuss, basically, because again, it saves the money to be rubbish. Um, yeah, not sure about the question about the gas capping, unfortunately. Um, so we'll call this the last question for tonight because we're at nearly at 8:30. Let me just put that in there actually. No more questions tonight. Can't spell questions at all, but anyway. So is it a must that you have to do everything in your they put in the personalised housing plan? So good question. Let me get up the Homelessness Code of Guidance because there's a nice little section in there about it. So can't remember which chapter, mind you. I think it's chapter 14. Let's have a little dig around. In fact, if we just go to the contents, that makes sense. Assessment, chapter 11. Okay, maybe. So there's basically there's mandatory steps, I think it calls it, and there's recommended steps. So let's have a look here. Be in this slot somewhere. Let's just zoom in so you can see what I'm doing. So, oh, where's everything gone? There we go. So, I'm gonna have to read this. Sorry, guys. Let me just recommended steps. Search for that. Recommended steps. Okay. Personalised housing plan may include steps that the housing authority can consider advisable for the applicant to take, i.e., recommended steps, but which the applicant is not required to take if they choose not to, as well as steps which they are required to take, mandatory steps. The irrelevant duty, prevention, or relief cannot be ended for failure to cooperate with the recommended steps. So if you don't, basically, I don't know if that means councils basically separate them out. It will depend on the council's kind of template PHP. So I don't know if it will say in the PHP whether they're recommended or they're mandatory, but certainly if they're mandatory, then and I would challenge anything that says you need to engage with support as mandatory, because I don't think that's within the council's power to make you go to a mental health service or whatever. There's plenty of good reasons not to want to do that. So yeah, but if you don't comply with the mandatory steps, then the council can end the relief duty, which has various consequences depending on whether you owed the main duty or not. I did a video about this somewhere, probably about the actual. I think there's a video called "What is the relief duty?" I'm pretty sure I explain it in quite a lot of detail there, and and it's quite complicated. So I remember I spent quite a lot of time getting that right. So I'm not going to try and repeat that in this live stream because I'll probably get a bit of it wrong. So yeah, but that's the short answer to that question. Will and Karish, you got anything to add to that at all?
No, I've never really had many disputes about personal housing plans. They all seem to be expressed in such general terms that it doesn't come down to a fight about yes or no. So, but one of these days I'll probably find a dispute over it.
Yeah, I think because it's quite difficult for the council to end their duty, because you've got to like warn people and kind of go through quite a lot of stuff to get that far. I think they're quite reluctant to actually bother doing it. Apologize for the video right now. My Zoom's been really weird. Hopefully everyone can see what's going on. It keeps flicking in between different views, but anyway, yeah. So questions that have come in after I gave that limit, if you can roll that over to next week. So either put it as a comment on any video on the channel and I'll get the notification, or if you want to come back next week and ask it then just make sure you get here nice and early at 7:30 so you can basically make sure the question comes in time. Other than that, guys, we will hopefully see you next week on this channel. Will, are we at your channel on Monday?
Yes, that's my plan.
Cool. I might not be here because I'm traveling down south, but I'll try to. Basically, I think I should be able to. But yeah, other than that, guys, hopefully this has been helpful tonight. Hopefully this is some stuff that you guys can put into practice, and we'll see you soon on one of our channels. So take it easy.